The Child Care and Protection Act, Section 9, Subsection 1, Cruelty to Children. Section 9 is on cruelty to children. Alright. Subsection 1. A person commits an offense if that person, being an adult or having the custody, care, or charge of any child, willfully A. Assaults, physically or mentally ill-treats, neglects, abandons, or exposes such child, or B. Causes or procures the child to be assaulted, physically or mentally ill-treated, neglected, abandoned, or exposed in a manner likely to cause that child unnecessary suffering or injury to health, including injury to or loss of sight or hearing or limb or organ of the body or any mental derangement. Subsection 2. A person who commits an offense under subsection 1 shall be liable A. on conviction and indictment in a circuit court to a fine or imprisonment with hard labor for a term not exceeding 5 years, or to both such fine and imprisonment. B. On summary conviction before a resident magistrate to a fine not exceeding $1 million, or to imprisonment with hard labor for a term not exceeding 3 years, or to both such fine and imprisonment. Subsection 3. For the purposes of this section, the persons specified in paragraph A to C shall, in the circumstances described in those paragraphs, be deemed to have neglected a child in a manner likely to cause injury to the child's health. That is to say, A. A parent or other person legally liable to maintain the child, who, being able to do so, fails to provide for the child in accordance with any duty imposed by Section 27 or 28. Right? So the parents or somebody legally liable to maintain the child, all right? Or B, an adult with whom an infant under 3 years of age was in a bed, where it is proved that the infant's death was caused by suffocation, not resulting from disease or the presence of any foreign body in that infant's throat or air passage, and 2, the adult was at the time of going to bed under the influence of drink, or any drug. So it could be that the person under the influence of a drug or a drink roll over and suffocate the child. C. Any adult having the custody, charge, or care of any child who allows the child to. Alright, so they allow the child to do these things. To be in a room, any room or yard containing any body of water, whether naturally or artificially formed or stored in a container. Here because say a child can drown. You hear about children drowning in a bucket of water. Alright. B. Any stove, coal stove, or open flame. So Don't allow the child to be in any room without any water stored or any flame or stove. 2. Having access to any poisonous or flammable substances. So it could be a bit poison like weedicide, insecticide, kerosene oil. Would that be a flammable substance? Not sufficiently protected to guard against the risk of that child being drowned, poisoned, burned, or scalded, as in the case may be. So it could be hot water too, right? Without taking reasonable precaution against the risk, and by reason thereof that child is killed or suffers serious injury. So you must make sure that you take reasonable precautions to prevent the child from going to the bucket or the stove or the weedicide, insecticide, or any other poison. Or don't make sure you put the matches far away from where the child can reach them. And don't allow the child to watch you light the stove, because they will go and do the same thing. But anyway, provided that neither this paragraph nor any proceedings taken thereunder shall affect the liability of any person to be indicted. Alright, let me read that again. Provided that neither this paragraph nor any proceedings taken thereunder shall affect the liability of a person to be indicted for manslaughter or for any other offense against the Offenses Against the Person Act. Alright, so you have the Offenses Against the Person Act. And this paragraph nor any proceeding taken under it shall not affect the liability of a person to be indicted. So the Offenses Against the Person Act is fully empowered, right, regardless of anything what is said. But anyway, subsection 4. Any adult other than an owner or operator in the circumstances referred to in section 40 who gives or causes to be given or sells or causes to be sold to any child any intoxicating liquor except under the order of a duly qualified medical practitioner for the purpose of treating sickness, or in case of other urgent cause, shall be deemed to have ill-treated the child in a manner likely to cause injury to the child's health. So, a doctor might prescribe a medicine and it cause drowsiness and so on. That's all well and good. But nobody should give to that child or allow the child to access any liquor, rum, hard, strong drink, alcoholic drinks. Right? They commit an offense against this act. Right? They would be considered to have, what they say, ill-treated that child. Right? 5. A person may be convicted for an offense under this section. A. Notwithstanding that the actual suffering or injury to health, or the likelihood of actual suffering or injury to health, was obviated by the action of another person. So, you say, a person may be convicted. Oh, so even though it might be somebody else who would actually do the deed, you can be convicted because maybe you never stop the other person or you allow them to actually commit that act. B. Notwithstanding the death of the child in respect of whom the offense is committed. Subsection 6. Upon the trial of any adult for infanticide or for the manslaughter of a child of whom the adult had the custody, charge, or care, it shall be lawful for the jury, if they are satisfied that the adult is guilty of an offense under this section, to find that adult guilty of that offense. Subsection 7. If it is proved that a person convicted under this section was directly or indirectly interested in any sum of money occurring or payment in the event of the death of the child, and had knowledge that the sum of money was occurring or becoming payable, then I guess it's like something like life insurance. Then A, in the case of a conviction or indictment before a circuit court, the court may impose a fine or sentence that person to imprisonment with hard labor for any term not exceeding 10 years, or impose both such fine and sentence. B, in the case of a summary conviction before a resident magistrate, the maximum amount of the fine which may be imposed under this section shall be $1,500,000, and the resident magistrate may, instead of any other penalty, sentence that person to imprisonment with hard labor for any term not exceeding 5 years, or impose both such fine and sentence. Subsection 8. For the purposes of subsection 7a, a person shall be deemed to be directly or indirectly interested in a sum of money if he has any share in any benefit from the payment of that money, notwithstanding that he is not a person to whom it is legally payable. So it could be that the person allowed the child to be hurt or killed, and that person going to get the insurance money directly, or that person has some relative or arrange with somebody else to share the money, because that other person go and get the money and share it with them. B, a copy of a policy of insurance certified to be a true copy by an officer or agent of the insurance company granting the policy shall be evidence that the child therein stated is to be insured has in fact been so insured, and that the person in whose favor the policy has been granted is the person to whom the money thereby insured is legally payable. So you have these persons who hurt or kill a child in order to get insurance money. Right? So this section protect that child from these type of persons. Alright. Subsection 9. Any reference to this section, section 50, subsection 3, or section 57, to a resident magistrate insofar as it relates A, to a resident magistrate for the parish of Kingston or for the parish of St. Andrew, shall be construed as a reference to a judge of the family court, corporate area region, and B, to a resident magistrate court for a parish within the geographical jurisdiction of the family court established pursuant to Part 2 of the Judicial Family Court Act, shall be construed as a reference to a judge of that family court.